what Texas has, and I commend our legislature for thinking of this, I wish it was used more often, but as an alternative to arbitration, we have Rule 151 of the Texas Rules of Civil Procedure. This only applies in civil cases, right? Any civil case can be applied to, but essentially what the parties must do, right, is they must waive their right to a jury trial. And I know you've heard me rail about that in other video series, right? The Founding Fathers gave you that for a reason, this, that, and the other. But when it comes to business matters, contract dispute matters, or if you're waiting around for a jury trial indefinitely, coronavirus matters, and it's a business dispute, Chapter 1 or Rule 151 allows the parties to waive the right to the jury trial, to hire a special judge. Now, this is something they do have to pay for, just like with arbitration, but they don't have to pay all the administration fees like the arbitration does, right? So special judge sits and can rule on any of the issues or a limited number of issues, reserving some for the trial court judge. But if you're going to do it, just have him or her. You know, it's usually going to be a senior, retired, civil, or what have you, district court judge. You know, if it's out here in Collin, Rockwall, Denton, what have you, it's a court of multi-jurisdiction judge, right? So it's just going to be a senior, retired district court judge, and they're going to weigh all of the facts, all of the evidence, and they're going to make a ruling that is binding, and more importantly, unlike arbitration, it's appealable, right? So and what happens at the end of arbitration? You're locked into it. You've either got to take your arbitration award and go open a new lawsuit, right? Or if you've opened a lawsuit at the beginning and then referred to the case at arbitration, you've got to take your arbitration award, file it in the district court where the case is pending, have the judge basically say, yep, that's the final judgment, issue a final judgment based on the arbitration award, not appealable unless really rare circumstances like the arbitrator was biased and didn't disclose some of the friendships or relationships. It's a very, very high burden. I don't want to say impossible, but extremely difficult burden to set aside an arbitration award. Rule 151, you don't like what you got a right to a direct appeal, right? You take it up to the Court of Appeals, you know, and you can appeal that from there to, you know, petition for permissive review, right? Permission for permissive review or discretionary review at the Texas Supreme Court. So it's a final appealable ruling and then judgment, and it's reviewable on appeal. So it just skips the step of the jury, and it skips a lot of those arbitration administration fees. So if you're about to enter a big commercial contract or a big commercial construction contract or what have you, any contract where the other side is asking you to waive your right to a jury trial, think about Rule 151, right? Instead of arbitration, which can be cost prohibitive, especially if you're a small subcontractor. I've seen this happen so many times, right? Sub is doing great work. General contractor says, I can't pay you right now. Sub has all these jobs, right? They total 40 grand, all of them under a binding arbitration agreement. He doesn't have 5 grand at that moment. He's got to feed his kids. He's got to pay all his workers. He's got to pay the vendor, right? He doesn't have the money to go arbitrate and then hire his own attorney, then all the arbitration fees, right? He can afford the $330, $340 at the district courthouse, right? He cannot afford the arbitration fees. So these things can be unfair, and I'm not saying they're used unfairly, but they can have an unfair result. And remember, fair is what you get in Dallas in the fall, not at the courthouse. So Rule 151, if the other side wants you to waive your right to a jury trial in a civil matter, think about Rule 151. Absolutely, hire a third judge. The parties have to split that cost. It's a single judge, no administration fees, and it's just a final ruling, right? It's a final trial, final ruling. You pay that judge for that day, that 2 days. You put on your case, they put on theirs, boom, it's over, right? It can be an alternative to these binding arbitration clauses and these big arbitration costs. Anyway, think about it. If you have additional questions, chat at ashmorelawfirm.com. Chat at ashmorelawfirm.com or text Ashmore X2 to 47177. Ashmore X2 47177. Thank y'all.